Welcome to the 2024 Ross Parsons Corporations Law Lecture, hosted by the Ross Parsons Centre here at Sydney Law School. Just before I introduce our speakers for this evening, I did just want to note, of course, that we're undertaking this discussion tonight on the beautiful grounds of the Gadigal people of the Eora Nation, and we acknowledge their elders past and present. By way of housekeeping, I would just note that this session is being recorded, but we aren't going to record the Q&A discussion at the end, but we will have a video recording of the presentations. It'll be made available hopefully sometime next week. So we'll send that to all of the registered attendees. And we'll also post it up on the Sydney Law School events and YouTube page. At the conclusion of the discussion this evening, we will have some drinks and canapes here, and you're most welcome to join us. Before introducing our presenter and commentator for this evening, I would like to just say a few words about Professor Ross Parsons. So this particular lecture series is funded through the generous donation of the legal profession and others who studied under Ross. Professor Ross Parsons graduated from Sydney University with the University Medal in Law in 1944. After working as a solicitor and then a barrister, Ross took up an academic position at the University of Tasmania and then subsequently the University of Western Australia. Ross joined Sydney Law School as an associate professor in 1957 and then became a professor of law here at 1961. And throughout his time in the law school, more than 30 years, he had a leading role in the commercial law area and, of course, the taxation area within the law school. He retired in 1986. Ross was awarded an honorary Doctor of Laws in 1999 from the law school. And the impact of Ross's contribution to the life of the law school and its students for over many generations is really hard to measure. Ross was instrumental in the establishment and maintenance of the law school's Master of Laws program, which at the time in the 1960s was something of a revolution, and then formed the basis of the model of postgraduate legal education in Australia at other universities. And of course, Sydney Law School still has one of the leading postgraduate law programs in the world, not only here in Australia. Ross has worked with the Committee for Postgraduate Studies, provided seminars for the legal profession, and established an important link between the work of the law school and its leading scholars and the legal profession. And that link continues today through the work of the Ross Parsons Centre. And I'm pleased to be the director of the Ross Parsons Centre for Commercial, Corporate and Taxation Law. And we have a host of events throughout the year. Most weeks there's an event on, and you can find details on the law school's events website. While Ross was a professor here in the law school, he was famous apparently for distributing his notes on various aspects of law. His notes, particularly on taxation law, which were over 1,000 pages long reportedly, were very popular with his students, then went on to form the basis of his seminal work on Australian taxation law, which was published by Law Book Company, and is actually available as an ebook on the Ross Parsons Centre website if you are interested. That was published in 1985. When Ross passed away, sadly, in 1999, a charitable fund was set up to honour his memory, with great thanks to members of the profession and the business community and his former students who made contributions. I would like to actually read out the dedication in the establishment of that trust because I think it speaks volumes to the massive contribution that Ross made, and it's appropriate that we honour his memory and legacy with this lecture series. The establishment of the charitable trust notes Ross's contribution to the study and development of taxation and commercial law was enormous. His wisdom, enthusiasm and learning were an inspiration to us all. More than one generation of those in the profession owes a great debt of gratitude to Ross, and we would like to show this gratitude in a more tangible way through the establishment of an annual lecture series to be called the Ross Parsons Lecture in Taxation and Commercial Law and Corporate Law, to be held each year at the University of Sydney. The goal of this lecture fund, which provides the funding for this particular event and allows us to attract some of the finest legal minds in the world to come and give the Ross Parsons annual lecture, The goal of the fund is to bring to Australia leading experts in taxation, commercial and corporate law, and to encourage Australian experts to participate and share their experience and knowledge. And tonight's lecture is a fine example of these goals. Our Ross Parsons Corporations Law Lecturer for 2024 is Professor Susan Watson. Her topic tonight is the significant origins of the modern corporation. Professor Watson is the Dean of the University of Auckland Business School, and she holds joint chairs in both the Business and Economics Faculty and the Faculty of Law at the University of Auckland. Professor Watson is a former president of the Society of Corporate Law Scholars. She's a research member of the European Corporate Governance Institute, and prior to becoming Dean of the Business School at Auckland, she was Deputy Dean of the Faculty of Law and the Head of the Department of Commercial Law, all at the University of Auckland. Professor Watson previously, before her academic career, worked in private practice as a solicitor in New Zealand, and her research spans the breadth of corporate law, capital markets law, and corporate governance. Professor Watson has published over 200 scholarly articles and book chapters in these areas, and her notable books include Corporate Governance After the Financial Crisis, Global Capital Markets, A Survey of Legal and Regulatory Trends, Innovations in Corporate Governance, Responsible Leadership in Corporate Governance, a research handbook for boards of directors, companies and securities law in New Zealand, and corporate law in New Zealand. Her latest book, for which she's speaking about tonight as part of the lecture, is entitled The Making of the Modern Company. See a picture of the cover there. It was published in 2022 by Hart Publishing in the UK, and Professor Watson spent over 10 years conducting the research and writing the book. The central thesis of this book is that legal personhood that attaches to an entity containing a corporate fund provided by shareholders is both a direct and inevitable consequence of limited liability and the company's status as a separate legal entity from its shareholders. The book challenges orthodox notions of shareholder primacy that are grounded on the view that the relationship that underpins corporations is inherently contractual in nature. Professor Watson challenges this view by going right back to the very origins of corporations and then tracing their development and evolving use through the generations. And she's going to share that research with us tonight. If you can join me in welcoming Professor Susan Watson.
Well, thank you, Jason, for this great honour and generous invitation to be giving the 2024 Ross Parsons Lecture. And thank you also for the plug for my book. I can feel confident that at least 3 people have read my book. And when you write a book like this, that's not too bad. And I know, of course, 2 of those people are always mum and dad, aren't they? But and the third person's in the audience, Tim Bowley, who actually helped, was essentially the editor of the book and told me all the parts that I should leave out because there was a lot I wanted to put in there. And he said, no, it's very interesting, but only to you, Susan. So, so thank you, Tim. I guess as Jason in his introduction talked about, the book really challenges some of the orthodoxies of our understanding of the modern corporation. And if we think modern corporation, there's anything esoteric or insignificant about talking about modern corporations, then I think we just need to look at the world that we're living in and the extent to which corporations, invisible, amorphous corporations dominate the world. And I want to link why I take that perspective of corporations as being invisible, amorphous, and actually incredibly significant by tracing back to their origins. And it's essentially a counter to perhaps what's the dominant understanding of corporations in law at the moment, which is that they are essentially contractual, as Jason said. And essentially, the core argument I make is that they're this thing called an entity, and that essentially corporations have evolved to that point at least 3 times in the cycle of the existence of corporations. Now, this very point actually came up subsequent to when I'd written the book in the UK Supreme Court in a case called Secorna, which many people will be familiar with as an insolvency law case, where essentially the UK Supreme Court determined that there are circumstances where directors can owe duties to creditors. But within the lead judgment of Lord Briggs in Sakona, there is a statement where he kind of draws a line in the sand where he lands on this issue. And fortunately, perhaps I would say this, but fortunately, I think he lands on the entity side. So he says, put shortly, the two strands of the reasoning in the Salomon case, namely the company as a separate entity with its own interests and responsibilities, and the company as an abstract equivalent of its shareholders, it is the first which has clearly prevailed over time. So those are probably the two dominant theories or understandings of what a company is. And it's interesting, isn't it, that we have to have theories about something which is so significant, but it is theorised about those two theories, that the company is an abstract equivalent of its shareholders, or the company is a separate entity in its own right, or Lord Briggs and the majority judges, I guess, in the UK Supreme Court thought it was the former that had ultimately prevailed. And for that reason, Sakona can be seen as a turning point in the law, or at least a landmark case, in the same way as Salomon and Salomon, which you'll all be familiar with, where the court said essentially established that a company is, again, a company is a separate legal entity from its shareholders. That was also a landmark case. Now, it'll be very apparent to you as you watch this presentation that I do my own PowerPoints, so please bear with me. So this is one of my PowerPoints. And that's a drawing of a corporation, or an illustration of what we might say a corporation is. And it's a pretty simple picture. And you'll see at the core of the corporation is a corporate fund. And that's the capital contributed originally by shareholders. And that's what fuels or sits at the centre of the corporation. And the corporation is a legal form as an entity. It's an entity that operates in the world, fueled by the capital of shareholders. Now, that's a completely different drawing. If you've seen the drawings of a corporation, it's a nexus of contracts or a nexus for contracts. It's a different, particularly as a nexus of contracts. There are no contracts in that diagram. So you might say, well, the next stage is who? And then it's really apparent now, isn't it? I do my own PowerPoints, but you might say, well, how does this corporation operate? Well, there's two aspects to it. Obviously, there are shareholders and they have shares, and those shares give them certain rights. Certain rights, obviously, you'll be familiar with the certain rights to aspects of to receive dividends, for example, voting rights, all those particular rights. But the shareholders, at least in this diagram, aren't part of the company. They just have shares that give them rights that connect with the entity itself. And then also shareholders collectively can operate through what we call the general meeting to make decisions about the company. And they make those decisions collectively as the general meeting, which has sometimes been described as an organ of the company. Now, of course, so many of the decisions that are made about the company aren't made directly by the shareholders, but instead by the board of directors. And in a sense, the board of directors drive the company, and shareholders appoint the directors to the board, but they do not directly control the day-to-day operation of the company. That's the job of the directors or the board. So these two organs, if you like, the general meeting sits more remotely than the board of directors, which controls the operation of the company. So far, probably fairly orthodox perspective of what a company is and how it operates and its key governance characteristics. But there are some questions that are left open when you think about what the company is. And they're questions like, what is the relationship of this corporate fund? So if I'm right and there's a corporate fund that fuels the company, well, is that corporate fund sit at the centre of the entity, or is it somehow like the fuel that powers the entity that's somehow separate from it? And that matters because obviously that corporate fund is contributed by shareholders, so that then determines what the relationship of shareholders is to the company. And perhaps more centrally, we talk quite freely about a corporation being an entity or a separate legal entity, but what is an entity? And for those people familiar with the principles of private law, where does an entity fit? in our understanding of private law. So I think, or I attempt to draw on history to try and understand, find some form of answer or possible answer to what those questions might be. So let me take you back in time and back to the beginning of corporations. So we use the terms company and corporation quite interchangeably and freely. So in New Zealand, where I come from, we tend to talk about companies. I think in Australia, people tend more often to talk about corporations, but it's interchangeable. In the UK, they talk about companies primarily, and in the US, they talk about corporations. But we all understand these terms as interchangeable and essentially that both are the same thing. But as we'll see, as I continue, the origins of the two terms are actually quite different. So the corporation form arose as the earliest form, and the corporation form had some origins in Roman law, but essentially was a form that was used in the Middle Ages for public purposes. So essentially, a corporation, and the earlier term that was used was actually universitas, which again shows the link with universities. Universitas was essentially a collective of people. And those collective of people were essentially recognised often by the law. So, for example, a municipality. So the City of London was recognised by the law as a municipal corporation. But the collective of people who lived and were citizens or occupants of London pre-existed it being recognised by the law as a corporation. And then essentially the corporation could be recognised or it could be essentially chartered. So some municipal corporations were chartered. So some cities were created by a charter, which was a royal charter, and essentially the king or queen of the day would agree to the petitioner's request that a municipal corporation, that a city be created, or an ecclesiastical corporation would be created, or other forms of corporation would be created. But they were created always for a public purpose. And they were the system of government, with the power being essentially delegated from the Crown to allow the municipal corporation or the other forms of corporation to operate. So essentially, the requirement for the petitioners to get the consent of the Crown to create a corporation was that you had to show a public purpose. So you might say, well, where do business corporations fit in there? Well, business corporations were essentially a subset of all the different types of corporations that existed. And they were given charters because they were considered to have a public purpose once the petitioners persuaded the Crown that the furtherance of commerce was a benefit to the nation and was a public purpose. So the earliest forms of business corporations were petitioners applying to the Crown for a charter for a corporation on the basis that it had a public purpose, because the furtherance of commerce, which it usually initially involved either mines or trade, was a benefit to the nation. So business corporations legally were just a subset, and initially the corporation was really based on the people who were part of it. Now, into this idea of the corporation came, if you like, an intervener or a different concept. And this was a concept that F.W. Maitland, who was a famous legal historian, called the Italian theory of the company. And this was a different idea of what a corporation was. And that idea was derived from canon law, and it was a particular solution that was created by the canon lawyers for a problem that beset the church in the Middle Ages. And that problem was that sometimes priests misbehaved. So the problem was, well, if the church was comprised of the priests who were part of it, that somehow infected or made the church potentially in some way a wrongdoer. So a clever lawyer who became a pope, Sibelius, who became Pope Innocent IV, put forward this concept that essentially the church was a separate entity, or a persona ficta was the term used, and it was separate from the people who were part of it. So the church was separate, the corporation, the church was separate from the people, the priests who were members or representatives of the church. So that concept of a separate legal entity was starting to emerge from canon law and essentially solving the problem of separating the church as the corporation from the priests who were part of it or represented it. So that was called, that's why, because it was obviously came from Italy, from Pope Innocent IV, Maitland called this the Italian theory of the corporation, the persona ficta idea, artificial legal person. And that was introduced into English, into the common law in 1612 by Lord Coke. And Lord Coke, of course, was a famous jurist and also in both the time of Elizabeth I and also James I, quite a significant figure in the court of the day. And he had to decide a case which involved Sutton. Sutton was the richest man in Tudor Elizabethan England or in Jacobean England. And in his will, Sutton wanted to leave some of his many riches to establish a school. And so he, while he was alive, he created a corporation that would own the school. And the school actually, if you're familiar with the Charterhouse School in London, it was that school. So it did actually become a school and it still exists in some form today. Now, its heirs challenged the bequest. And the grounds that they challenged the bequest on was that they said, well, at the time that this corporation was created, this corporation for the Charterhouse School, the land hadn't actually been acquired or wasn't owned by the Charterhouse Corporation. So therefore, there couldn't be a corporation because it wasn't based on anything. So Lord Coke introduced this concept of persona ficta or separate legal entity and said that it was possible for a corporation to exist in the abstract. It didn't have to be based on anything. So he brought this notion in to find a way, I guess, to give the outcome that perhaps, he wanted to give in terms of the justice of the case, and said, well, you don't have to have a corporation based on anything. It doesn't have to be based on people. It doesn't have to be based on land or anything. It can be exist in the abstract, in abstracto, he said. So from that point on, corporations in the common law were persona ficta or artificial legal persons. They didn't have to be based on people. They were separate from people. So the Italian notion, the canon law notion, comes into the common law. So that's my AI help with this one. That's the concept of the corporation existing separately from the people. And from 1612, all common law corporations were persona ficta or artificial legal persons. They were entities existing in the abstract, persona ficta. They were treated by the law as legal persons, but they were artificial legal persons. They were created or came into being only through an act of incorporation, which was a charter in those days, as opposed to being recognised as being corporate because they were made up of people. Now, you might say that's a head of a pin distinction, but it's still quite significant because these corporations were real once they were created. And there's an analogy that was used by Machen, who was a writer writing about the persona ficta. And he said the persona ficta or artificial legal person idea of the corporation, well, it's the same as if you have an artificial lake. It's created artificially, but it's still a lake. So once the persona ficta corporation came into being, even though it existed in the abstract, it was a real thing. So if you had to draw it, you could say it's that. It was an entity created through the act of incorporation, but it didn't have anything in it. It was just existed in the abstract, the persona ficta. Now, there's another part of the story that relates to joint stock funds. So joint stock funds were a way in which privateers originally or people could join together for long-term ventures. And as you know, during the Middle Ages or during that period, they had the usury laws. So it was difficult to, well, in fact, it was illegal to lend money. So they found a way around that by saying that you could essentially all combine in joint stock, and at the end of a joint stock period, you would divide up the proceeds, or divide up everything at the end. And joint stock funds were used in the Middle Ages, but became more significant with the introduction of double entry bookkeeping, again another Italian invention, but introduced into England in about the middle of the 16th century. And that was important because double entry bookkeeping, as you know, it separates the input of participants, which is their capital, on one side from the participants on the other side. So again, you see another sort of separation happening. The separation of the capital or the fund from the people who contribute it. But that was a separation for accounting purposes. It wasn't a legal separation because double entry bookkeeping didn't have any, it was an accounting mechanism, it wasn't a legal mechanism. So joint stock funds were based on the stockholders who founded them. They weren't legally separate from them. And of course, one of the famous early users of joint stock were privateers like Francis Drake, who formed private joint stock companies to fund the voyages, the privateering voyages. And often the stock that was contributed, sometimes it was money or capital, but it could be actually stock, could be goods, provisioning of the ships, could be the ship itself, or it could be the labour of the sailors. So everybody contributed and received a share. And at the end of the voyage, essentially, the proceeds were sold and everything was split up, and that was the end of the relationship. So joint stock funds allowed these long-term ventures, longer-term ventures, but of course they ended at the end of every voyage. So the joint stock of the company, and they were called companies, was seeded by the capital of stockholders, but it was separate from those stockholders for accounting purposes, but not legally separate. Or to illustrate it another way, everyone had a share, but that could be they provided something different. They didn't have to provide capital, they could provide the ship or the labour or the provisioning. So if you had to draw it, you could draw a joint stock fund like that. There's no legal separation, there's no entity, there's just the joint stock fund, or the corporate fund, if you like, that's shared by the shareholders. And at the end, it's divided up. So those are the two pieces of the puzzle, if you like, that were combined eventually. And they were combined in some of the business corporations that existed after the middle of the 16th century. And the most significant of those, because of the way it evolved, was the English East India Company. So the English East India Company is enormously historically important for lots of reasons, but one of the reasons that we don't talk about very much is that essentially it had all the features of a modern corporation by the end of the 17th century. But it didn't start off like that. It started off in 1600 as being chartered for a public purpose, the furtherance of commerce. Was chartered by Elizabeth I, obviously not long before her death, and actually, interestingly, on, I guess, the very last day of the 16th century, 31st of December 1600. So interesting that this was essentially became one of the key factors of the modern age, and that's turning point. And if you wanted to be a member of the East India Company, you paid an amount. So people could apply to become members of this corporation, which had been chartered by the Crown, and you paid something like £5, and then you were a member of the company. And the East India Company was a corporation that within it, the members of that corporation could choose to invest in joint stock funds. So that joint stock funds were established for voyages, and each member could decide whether or not they would invest in that voyage and in that joint stock fund. And what happened through the first part of the 17th century is that there was a sequence of voyages that were funded by joint stock funds. And at the end of each voyage, it was always the intention that the East India Company would continue, but the funds would end. So all the proceeds would be divided up, the ship would be sold, and the whole venture would come to an end. Of course, that could last several years because these voyages, which had many ships, went to India, bought up or traded all the goods, often processed them in some way in factories that they built, and then they brought them back to England and sold the goods. Or as we'll see, actually, sometimes they didn't sell the goods, they actually distributed the actual cargo, like pepper. So all the people who had shares received something like pepper. Now, the East India Company, the first two voyages were actually ended up being combined, the joint stocks. So the first joint stock was still in existence when the second joint stock was set up. And so you had an interesting problem or an interesting challenge because the first joint stock investors put in money that was used to build the factories in India. And then the second joint stock investors got the benefit of those factories. And there were some debates, and all these debates are recorded in the minute books. They kept minute books where they recorded what they were debating. They debated things like agency problems, all sorts of things that we consider modern problems. But one of the problems that they had was how did the investors in the second joint stock fund compensate the investors in the first joint stock fund for the cost of building the factories. And then that continued to be a problem with the third set of voyages and the fourth set of voyages. And really we can think about the development of the East India Company during this period over three sequences of 20 years. So the first 20 years was the period from around 1600 to 1620. And it was plague exigencies that meant that that first and second voyages were combined. The shares that people had started to be traded on secondary markets. You have the emergence of type of capital markets because of the length of the voyages. The enterprise operated over several years. And in the end, ultimately the return on investment was 187% of what people had put in. But very complex issues to be sorted out between the different members who had invested in different voyages. Now, the second 20 years weren't as successful as the first 20 years. So financial woes meant that they reverted to single voyages with separate joint stock funds. But those voyages were still profitable because they could use the existing factory infrastructure. But there was a lot of confusion between who owned the joint stock funds, who owned the factories in India, all those sorts of issues. And there were also competition from free traders who said, well, why should I become a member of the East India Company and join in one of these voyages? I just want to take my own ship and do my own trading. And so that's where the word interloper came from, which were these free traders. So investors lost faith in the East India Company, and they said that the beadle went round with the book and none of the members would put money in. And one of the other interesting things that developed was also you had the majority shareholders, which were the original founders of the East India Company, who had become wealthy from privateering the previous century, and they were the majority shareholders and they controlled the governing body. And then you had the small investors who were often like the youngest son of gentry, shopkeepers in London, ship captains, who were the investing shareholders, and they often had small stakes. And initially when the East India Company operated, it was the majority shareholders got their own way. They were all merchants. They made sure that the distributions happened not in cash but in commodities, which they could on-sell. But if you were the youngest son of a member of the gentry, having a consignment of pepper landing on your doorstep, there was not much you could do with it. So over time, the generality through general meetings, and that was again another East India Company innovation, they insisted on rights. So they insisted on they wouldn't invest unless they received cash for their dividends. They didn't want commodities. And they also insisted that the majority governing body act in the interests of all of the shareholders, not just the majority. So you can see all these modern principles of corporate law emerging much earlier perhaps than we thought in the 17th century. So in terms of a diagram of what it looked like, you can see there was a governing body, but a very complex governance structure, because to be able to invest in one of the joint stock funds, you had to be a member and pay £5. But each joint stock fund had different shareholders, and it also had different directors. So there were different directors for each joint stock fund, and they were all members of the overall governing body for the East India Company. So very complex structure and all sorts of coordination problems and challenges that existed. And so that called for a reform of governance and also eventually for a reform of the structure. So by the time of the English Civil War, they were calling for one joint stock, and essentially that was permanent capital. So they said instead of having these terminating funds, we should have permanent capital, one joint stock. And they were copying, they didn't come up with that idea. The Dutch East India Company had introduced that, but the Dutch East India Company didn't have double entry bookkeeping, so they didn't separate the funds in the same way as the English. They called for one joint stock, and by the time the third period of 20 years came along, you had the Civil War. So, of course, that called into question whether the charter for the English East India Company was valid, because it was a royal charter. And by the end of the Civil War in 1651, Cromwell considered the English East India Company from a national perspective, and he thought for the public interest. Ultimately, he was persuaded that it should have permanent capital, which happened in 1657. So from that point on, you could say that the English East India Company had all the features that are key for a modern company. It was a separate entity, an artificial legal person, separate legal entity. Through double entry bookkeeping, the corporate fund was separated from the investing shareholders. So it had all those key features of a modern company. And also, as John Evelyn, the famous diarist, said, at the time of the establishment of the East India Company, they swore new oaths. And the new oaths that he talked about in his diaries were an oath by the governing body to act in the interests of all of the investors. So you also had also a form of modern governance. So you might say, well, so what, that's interesting, maybe, maybe not, but did it matter? The really interesting thing is that from the point that the English East India Company developed its modern structure, it prospered. Now, there could be lots of other reasons why it prospered, and certainly having royal favour helped. But in the period between 1657 and 1691, proprietors, investors like John Evelyn, received 840% in dividends. And dividends were paid nearly every year. And this is from a point where the English East India Company had nearly failed. And its share price quadrupled, went from 60 to 70 pounds in 1664 to 245 pounds in 1677 and 300 pounds in 1680. And you might say, well, yes, all sorts of reasons that might have happened. But very interestingly, before it got permanent capital, the English East India Company was failing, and it was sort of third in the league of East India companies. So there was the Dutch East India Company, the VOC, and the Portuguese East India Company that were far more prosperous. But within a very short period of time, within about 30, 40 years, the English East India Company had surpassed them all. And that was from the point that it acquired its, if you like, modern corporate form. So I think that's interesting when we think about the advantages of having the corporate form, or the advantages that the corporate form offers. Now, essentially, I haven't got time to talk about what happened in the 19th century, but essentially we had the same process happen, where at the time that the general incorporation statutes were introduced in the middle of the 19th century, it was very clear that the legislature meant a company to be based on its shareholders. So you think back to Lord Briggs' idea. The second of those ideas was the idea that the legislature clearly favoured, but also very clearly, within 40 years by the time of Salomon, the company was understood to be a separate legal entity from its shareholders. And there are a number of factors that caused that, harking back to the earlier form of the corporation, but also limited liability, which separated the investing funds of shareholders from the shareholders themselves for accounting purposes, and then eventually for legal purposes. So Secorna, a turning point in the law, because again, there have been different theories or understandings of the corporation in the intervening period. But Secorna, at least in the UK, seems to have drawn that line in the sand and said that the company is, or the modern corporation is, in fact, a separate legal entity from its shareholders. And you might again say, well, what does that matter? Why do we care if we say it's based on its shareholders or an abstract representation of its shareholders or separate from them? It's because of the potential that can be realised by the corporate form, especially when it scales to a certain size. And that was recognised in a famous book by Burley and Means in the 1930s, but also Joshua Child in 1601 called the modern corporation a fund of wealth. So very early, much earlier again than thought it was recognised. But it also creates a problem for the law, because in law we think about, when we study or talk about company law, we talk about it as a private, essentially a private, we talk about it within private law paradigm. And within private law, we recognise persons, actions and things. And so the modern company within private law is a legal person, but the modern company is really an entity. It's an artificial legal person, but it's an entity. It's something else when it operates in the world. It's more than just a legal person. And in private law, we talk about contractual relationships between different parties or participants, like shareholders in the company, or we talk about the stakeholders in the company. But the modern company or corporate, like an old-style corporation, is an entity. And there's just no room to, or no way to fit an entity into the private law of persons, actions and things. So one of the questions I want to pose really is, should we start to think about modern corporations which are authorised to exist by the state through the process of incorporation, should we start to look at them more through a public law lens? The other key point is that the realised potential of the corporate form as an entity, and that seems to happen when it reaches a certain size or scale, because essentially the scale it can reach is unlimited. And these corporations are unparalleled aggregators and sources of value creation over time. You can take ideas and create them at unlimited scale, and they can exist for an unlimited period of time because they don't have a lifetime. They're essentially immortal entities. They outlive human lifetimes. And there's no question that they've lifted the overall standard of living across the world, although unevenly, and mainly to the benefits of shareholders and controllers, but many of us, through different mechanisms, are shareholders today. And also at the expense of creating externalities, because as these entities operate in the world, they have an impact on the world, which isn't always positive. So, and also in their history, there's been 3 cycles. So the English East India Company existed for a period of time untrammelled, but then did such harm as a corporation that it was reined in by the state, essentially nationalised after about 100 years of operating as a corporation. Similarly, the Gilded Age, those massive corporations, Standard Oil, they also became enormous and were reined in by the state by the introduction of antitrust or competition laws to essentially break them up. And then we have our, if you like, our 3rd cycle, which is our tech companies, which again are becoming enormous across the world. So this corporate entity, they exist in the abstract, but they're real. Then they have an impact on the world and they actively operate in the world. They're not a passive nexus of contracts. And they exist because they're authorised to exist by the state, and the incorporation artificially creates the entity. So this corporate entity has its own rights and obligation. When it ceases to exist, we're left just with that old fund, that joint stock fund. The entity incorporation part ceases to exist, and you divide up the fund in liquidation. So that simple picture, I would argue, illustrates what they are. So a final thought on this idea of the significance or size of corporations. So Mark Zuckerberg talks about companies, not countries. And in a speech at the F8 Developer Conference in 2017, he said that technology could bring people together to form a more unified global community. And he mentioned this concept of companies, not countries, as a vision for the future where global companies and networks could transcend national boundaries. And when someone asked him what he really meant by that, he said, I think we're moving to a world where we're cells in a single organism. Now, if you think of that single organism as corporations, well, it's not a benign organism in the sense that it has controllers. And those controllers, as we saw with Zuckerberg, with Elon Musk, with the fuss over his remuneration, those controllers are the tech founders for these corporations. So, as John Lennon said, imagine there's no countries. And there's perhaps a vision of the world as we might see it in the future. Thank you.
Thanks very much, Susan. Very thought-provoking. I'm sure there'll be lots of questions. I'd now like to introduce our commentator for this evening, which is the Honourable Justice Ashley Black from the Supreme Court of New South Wales. Justice Black was sworn in as a judge of the Supreme Court of New South Wales in 2011, and I'm proud to say that he is an alumnus of both Sydney University and Sydney Law School, having graduated with first-class honours in both arts and law. Prior to his appointment to the bench, Justice Black was a partner at Mallison Stephen Jakes here in Sydney. Justice Black teaches several units in our master's program, which I mentioned at the start of this evening's affairs. And I'm really pleased that Justice Black is able to provide his comments tonight because he is undoubtedly one of Australia's foremost corporate law scholars and is the author of several leading texts, including Austin and Black's Annotated Corporations Act, Australian Corporation Law Principles and Practice, and Securities and Financial Services Law. If you can join me in welcoming Justice Black.
Ladies and gentlemen, we are of course fortunate to have had the benefit of Professor Watson's presentation, which, as Jason has noted, draws on her book, The Making of the Modern Company. I will comment both on the presentation and on her book in my comments. I'll try and be no more than about 10 minutes, which will leave plenty of time for discussion. The first thing which I should note, and I'm still struggling with the shock of this, is that Professor Watson's view of the company is, I think, truly remarkable in its orthodoxy. That is perhaps a surprising proposition amongst modern commentators on company law. She distinguishes between the company and its shareholders and its directors, and she points to those assets that are contributed by shareholders and properly and likely creditors, which she describes as the corporate fund. This all sounds, one might think, like a wholly orthodox vision of the company, which has much in common with our company statutes. She draws on history in support of her analysis, and I'm going to spend most of my comments on her historical analysis. I'll come back to the proposition that that history is absolutely worthwhile for its own sake, but I will also come back to why it seems to me that Professor Watson's analysis will not convince those who take a different view, for example, the nexus of contracts view, who are simply travelling down a parallel rail track, which will not be affected by her analysis. Professor Watson's presentation today reflects, at least in part, the first part of her excellent book, which deals with the historical development of the corporation. And that part of the book is, in effect, a history of English company law, and it has received at least one extended and admiring review of its analysis. Her thesis, as Jason pointed out, is that the modern company first emerged in the middle of the 17th century as a vehicle for raising long-term capital. And she treats, I think it's fair to say, the first modern company as the English East India Company, which we've seen today in her presentation, although she also refers to the Bank of England in that respect. Now, in her presentation today, Professor Watson has devoted several slides to the history of the English company, of the English East India Company, and she points out that that company had acquired all the key features that made it the world's first modern company. Her book similarly emphasises that proposition and points to several features which are plainly characteristic of the company: the right of suing and being sued, the ability to enter into transactions as a separate entity, the benefit of perpetual succession, and the development of the concept of a persona ficta, or artificial legal person, which she in turn links with developments in Italian law taken into English law. Her book in turn has in chapters 3 to 5 an extended analysis of the history of the English East India Company, tracing its developments, and she draws the interesting link, which seems to me to be an important link, with the development of double entry bookkeeping, so as to distinguish the capital of shareholders from the capital of the company. And that forms the basis of her concept of the corporate fund. I have no reason to doubt that Professor Watson is correct in her analysis of the features of the English East India Company. Of course, history poses a challenge in the sense that there are a number of factors which are predecessors to the modern company, but tracing causation or tracing origins is a little bit more complex. In particular, the coexistence of the features, which we see coalescing in the English East India Company, does not, of course, demonstrate, and in fairness to Professor Watson, she doesn't say it demonstrates, that those who were passing company statutes in the 19th century had the English East India Company specifically in mind, as distinct from it being part of the general history on which they were drawing, which also included plainly the joint stock companies and the deed of settlement companies, which Professor Watson also deals with in considerable detail in her book. Now, Professor Watson passed quickly over the 19th century today, and I'll take the advantage of the fact that I have another 10 minutes to spend a little bit, less than 10 minutes now, to spend a little bit of time on the 19th century. And in fairness again, Professor Watson in her book deals with these matters at considerable length. She traces the analysis through the Joint Stock Companies Act 1844, which she fairly characterises as restrictive rather than facilitative, before turning to the Limited Liability Act 1855, which came closer to the concept of a modern company, and then the Joint Stock Companies Act 1856 and the Companies Act 1862. She fairly notes in her book that by this time the statutes had become facilitative rather than restrictive, and that they introduced statutory limited liability of shareholders, both to the company and to third parties, which had become the default position from companies from 1856. This is important, it seems to me, because there is a strong case that at least the 1862 Act can be tracked through the structure of all subsequent company legislation in the United Kingdom and in Australia. So if you're asking a narrower question than Professor Watson asks, and asking where does the modern statutory form of the company come from, it is at least in part from the structure of the 1862 Act. I should add that in a familiar sequence of law reform and corporate failure, the 1862 Act was immediately followed by the failure of Overend Gurney and Company, a major financial firm in the United Kingdom. I didn't find a reference to that failure in the index to Professor Watson's book, but her index does tell us something else about the history of company law, because you'll find under the letter P references to the Panic of 1837, the Panic of 1847, the Panic of 1866, and one could, of course, add further panics to that distinguished list. Professor Watson points to the slow take-up of the corporate form in the second half of the 19th century. And that's an observation that is both important and accurate and reflected in other historical commentary over that period. But nonetheless, that form of legislation can be tracked through to more recent legislation. In her presentation today, Professor Watson also draws attention to Sequana and to the reference to Salomon in Sequana, and to the observation of Lord Briggs in Sequana that the vision of the company as a separate legal entity with its own interest has prevailed over a concept of the company as an abstract equivalent of its shareholders. It is no doubt an explanation of the fact that Lord Briggs is in the Supreme Court of the United Kingdom and I'm a first instance judge, that I struggle with what the concept of the company as an abstract equivalent of its shareholders might mean. But having said that, I don't have to puzzle over that proposition very long, since it appears that that model did not prevail. But Professor Watson happily provides an extended discussion of Salomon in her book. And that decision is, of course, generally treated as confirming two things. The first, which is an important theme of her paper today, that the company is a separate legal entity distinct from its shareholders. And the second, a controversial issue when the case was decided, that a company can properly exist, although it is controlled and owned as a matter of economic reality by one person. That decision has, of course, provoked equally strong approval and disapproval among commentators, both when it was decided and subsequently. Professor Watson has also drawn attention to the reference to that decision in Sequana. But one of the oddities of that reference is how that decision impacts upon the ultimate decision in Sequana, which is really a question of the scope of directors' duties to take into account creditors' duties to the company to take into account creditors in the region of insolvency. So the Supreme Court of the United Kingdom there accepts that such a duty exists, but points to its origin at a much later point than the Australian and New Zealand authorities would accept. There is, of course, a question, and it's not one that I can answer, which is how the proposition in Salomon is necessary to the decision in Sequana. And it's not apparent to me that you need to have a particular view of Salomon to reach the conclusion that the Australian and New Zealand courts have reached of a duty owed to the company to take into account the interests of the creditors, or indeed a duty of the kind that the United Kingdom Supreme Court has reached of a similar kind, but arising at a later date. I should make two further comments as to Professor Watson's historical analysis. First, we shouldn't forget that that analysis has real value for its own sake. So one can quite properly have an interest in that history without seeking to draw any lessons from the present from history. Second, Professor Watson herself is plainly conscious of modern debates as to the scope of corporate law, and the second part of her book engages very fully with those debates in a way which her presentation today has had to deal with more lightly. I should come back, however, to the question then, will Professor Watson's historical analysis convince those who adopt a nexus of contracts model that the company is a separate legal entity and that that analytical structure of the company as a separate legal entity, whether having developed historically or having being a creature of statute, is the preferable way to analyse it? The answer to that, and of course I am asking a question about will it convince, not a question about should it convince. The answer to the question, will it convince, seems to me to be probably not. And that is because these propositions travel on different tracks. Professor Watson deals comprehensively with the history of the English company. Those who adopt a nexus of contract model are indifferent to that proposition. They do not rely on the history of the English company to establish the desirability from their perspective of a nexus of contracts model. It is an explanation as a matter of theory of the way they say the company works. It doesn't depend upon those who developed the company, those who wrote the company law statutes, having the slightest conscious intent to adopt a nexus of contracts model. So it seems to me that those who would adopt that model will accept the history, or likely accept the history which Professor Watson points to, but say that that nonetheless provides no reason to adopt a separate entity model, whether in preference to, in parallel to, or instead of the model for which they would contend as a functional explanation of how the companies operate. But that, returning to where I began, is no reason not to be grateful for the presentation today or for the much more extended analysis in Professor Watson's book. That book is an interesting exercise in legal history. It addresses several current issues as to the role of the corporation. And I should say, for those who have a taste for it, it ventures into some of the deeper waters of legal philosophy. So returning to where I began, we are fortunate to have had Professor Watson's presentation today, and I commend her book to you for a more extended analysis of those issues.